So this adds, would you say, a legal nuance on the standing issue, Brian, that you guys didn't raise in your first round?
No. I believe this issue was germane not only in the first round, but what's unique about the JobsOhio case, which you have to keep in mind, is that the original legislation, as you may recall, the legislators themselves anticipated that there might be a challenge to the constitutionality of it, and in doing so, they limited you to the 90-day window in order to be able to file. And because of that, they created a situation where if a judge were to rule on standing based on the actual existence of the program or responding to some part of JobsOhio, there was no way to do that without filing suit within the first 90 days. So therefore, what these courts have actually found is a preclusion to anybody having standing in the court over this issue, and potentially allowing an unconstitutional provision in JobsOhio being upheld without any kind of judicial review.
Do you think the fact you were rejected in the 10th Circuit actually makes it
the 10th Circuit,
better this time?
the 10th Circuit decision is actually pretty interesting because they did talk about some of the substantial concerns that we had raised over the JobsOhio issue, and then they, and I'll let Maurice talk about it as well, but they literally ignored that and said you don't have standing because of this interpretation of judicial discretion. And so therefore, it would preclude anybody from being able to file any lawsuit in this case, not only because of the way it was written, but because of the way the law was constructed, requiring you to file within 90 days.
One thing that I'll add to that is that our brief emphasizes this circuit split or appellate district split in Ohio, which is very relevant. So many of you have probably heard this rule of thumb that if there's a circuit split in different federal circuit courts of appeals, the United States Supreme Court is required to take a case. The same is true in Ohio amongst the district courts of appeals. One thing that we noted and where we kind of picked up where Progress Ohio left off was they didn't know that there is in fact now a very distinct district court of appeals split in Ohio. The 1st and 4th districts in Ohio hold that taxpayers generally can sue to enjoin illegal government expenditures. And here the 10th district, along with the 12th district, distinctly rule the opposite way. So the court, at minimum, has to settle this dispute. And that kind of segues into my second point, in that we do emphasize taxpayer standing a little bit more than the Progress Ohio brief itself, because we believe that the two are related. Public interest standing as a citizen or as a taxpayer, necessarily all citizens end up being taxpayers of the state also. So the two are one and the same, and we do ask the court to consider them in the same vein.
I noticed that you were talking about legislators kind of self-protecting, building in. I also noticed in the Lake Erie water legislation they passed, they prohibited people from having personal rights to be able to sue the state over the Lake Erie water standard. My point is, do you think government is now insulating itself so people, citizens, don't have standing to sue it?
Yeah.
My answer would be yes, absolutely. And I think this is an area where whether you're right or left or Republican or Democrat, it doesn't really matter, or libertarian, this is a fundamental right of citizens and gets to the heart of the separation of powers in our state. And it is not only there, but in some of the land rights issues that they've been doing over the fracking issue. This is a major concern where legislatively some of the legislative games are infringing on people's rights to sue. And it's not that you want a litigious society, but you also need a balance here so that legislators do not ride roughshod over people's private personal rights.
Will the 1851 Center be contributing financially to the lawsuit or the appeal every year to the Supreme Court?
And not in a technical sense. We don't have any filing fee in order to do this. It's an in-kind contribution insofar as our labor is involved in the fashioning of the briefs. and will contribute in that sense. So there's a financial element, but there's no exchange of funds here.
So the extent of your cooperation so far is that you helped write the brief that was filed with the Supreme Court today, or?
So we're an amicus party.
Okay.
So what that means is Progress Ohio has their own brief that they've written. We did review that brief prior to filing our own, and one of the things that we did do in reviewing that was sought to pick up the slack if there were areas that they weren't able to address, either because of the page limitation or simply because their focus is elsewhere. Although we were, in doing so, able to perfectly address the issues that the 1851 Center cares about the most. So there's a very symbiotic relationship. But we're an amicus party to the case, so we are supporting the court taking jurisdiction of this case right now. Now, whether we continue to advance that support into the merits depends upon perhaps which substantive issues the Supreme Court might take, and at that time we'll make a judgment call on the quality of Progress Ohio's substantive arguments and whether we should support those as well. And also perhaps whether it might be appropriate to intervene at some point in order to present this taxpayer standing view to the court, because it is important and before the court and is from a different angle than is currently presented.
What's the difference between amicus and intervener?
An intervener is a direct party in the case. So you sue person B, and then person C sues both of you to get into the case. So they technically have adversity along with you. So we are not that. We are supporting Progress Ohio's side on standing.
Okay.
So this right now is focused on standing. If the Supreme Court accepts the case, says you do have standing, where does the 1851 Center for Constitutional Law stand on the JobsOhio, the substance of that lawsuit?
Well, I would say a few things. I'd say I'd like to reserve my judgment until I see which proposition of law they accept. The brief is unusual in that it asks the court to accept a great number of propositions of law. I think 8 maybe, was it?
Yeah,
The final?
I think I'd cut them down to 7.
Yeah, and that's quite a few, and so I'm sure the court won't take all of those. If it does, actually it's going to be very messy. So if they take a few, we'll see which ones they take, and if we like the arguments associated with the ones they take, we're not beyond supporting those aspects of the lawsuit as well. Ultimately, what JobsOhio is conferral of special corporate privileges upon a special corporation that is to use public funds to hand out to winners and losers chosen exclusively by the governor and people that he's chosen. We do view that as dangerous. We do view it as constitutionally suspect. There is an explicit prohibition against special privileges in the Ohio Constitution in Section 1, Article 2. There is an explicit prohibition against joint ventures between public aid and private corporations in Article 8, Sections 4 and 6. So it is constitutionally suspect. We will look at it, but at this time, we're only supporting on the standing issue.
So if they reject you now, you would be in a position to go to the U.S. Supreme Court? Is that what you're saying about the circuit split? Because before you had to appeal to the 10th Circuit, right?
Well, it's a district court split. It's an Ohio Intermediate Court of Appeals district court split. If they rejected, there would be a claim to the United States Supreme Court, but I don't think it would be very strong because this is an independent, this is a case brought up on the independent basis of the Ohio Constitution. The United States Supreme Court will typically not take those cases. A lot like our smoking ban challenge, we didn't appeal to the United States Supreme Court because we were emphasizing the Ohio Constitution.
So just so I understand, so the Ohio Supreme Court could rule just on the standing issue and send you back to a lower court, or they could say they'll hear arguments on the whole case?
Correct.
Is that right?
Correct.
Yeah, and they did that 2 years ago. There's a Barberton case challenging the legality of school district contracts, and we supported the ABC of Ohio in that case as well as an amicus party. And what they did was only accept the taxpayer standing issue on the issue of whether school district taxpayers have standing to sue to enjoin illegal school district expenditure. Now, for very strange procedural reasons, that case was eventually jettisoned as improvidently granted. which means that the standing issue never got addressed there. But that was the only issue that they addressed there, which is pretty unique. So here are the parties wanting their substance addressed, only getting the standing bite. But that's right. If they rule in favor of Progress Ohio on the standing, they would get to go back to trial court.
To Judge Beatty's court. And they did have some language about legitimate concerns in the original cases. You might recall we had to file in the Ohio Supreme Court originally. We lost but won, and I know that sounds weird, but basically the court ruled that they didn't have jurisdiction, the legislature couldn't make us file in the Supreme Court, sent it down to the trial court, which was what we argued, so we actually lost the case but won. But there was some language in the decision already from the justices about the importance of the merits of the case that we brought at that time. So I'm hoping that they will accept this. There's two hurdles. One, they accept to hear the case, and the second one would be that they rule on the case, and then that they would remand it and send it back down to go through the proper channels. And actually, finally, after over a year of this, actually have the court rule on the merits of the case, not some of these legal games.
So what do you do if they either decline to hear the case or rule against you on standing? Where does that leave you?
That's why I'm surrounded by great lawyers on right and left.
Do you have any other option at that point, other than to yell and scream? Or?
I don't know. I mean, I do know that it would leave in place a law which I believe at this point in time, I find it hard to believe that our Ohio Supreme Court would leave a program intact that could potentially violate the Ohio Constitution over a technicality. And I don't think that's good law, and I don't think it's good for the citizens of Ohio. And I'm saying that as a non-lawyer.
I'm the one that's supposed to be on the right, but unfortunately, I don't find it hard to believe because the court is very, very unpredictable. And we hope that doesn't happen because where that leaves us is really up the creek on these structural limits on government. If they deny the case, that means the 10th district decision stands, and that is an awful, awful decision. So we hope that doesn't happen.
Brian?
Yes?
Mark Kwame has said that this whole legal cloud, forces him to kind of keep one foot on the brake and not fully implement JobsOhio the way they see it. I guess, do you draw any satisfaction from forcing him to keep one foot on the brake and appealing this thing?
I don't find any satisfaction at all in this whole process. I think that, well, first of all, on the one hand, Mark Kwame can say that today, and on the other hand, he's running around the state of Ohio bragging about all the things he's done and bragging about how great the job situation is. So, this isn't about John Kasich, and it's not about Mark Kwame. This is about the Constitution of the state of Ohio. The same Constitution our governor swore to uphold, and the same Constitution he should be upholding. And our Constitution is very clear about the use of public funds in a private entity. And so I don't take satisfaction in it. I'm kind of sorry that I've had to be doing this for the last year.